Hello, everyone. I am Crystal Dillon. I am this year's Moot Court Board President, and I would like to thank all of you for attending the 2023 Hardt Cup competition. In its 59th year, the Hardt Cup competition is the premier opportunity for first-year law students to develop their oral advocacy here at Duke Law. Today, our finalists, the students will argue the case of Campbell v. Raich, which considers whether an elected official's blocking of a constituent on Twitter constitutes an infringement of their First Amendment rights. A larger synopsis of the case can be found in your programs. I would like to begin by thanking Judge Eagles, Justice McMillian, and Judge Richardson for taking the time to prepare for today's arguments and to join us for the Hardt Cup final round. The finalists and the Duke Law community benefit from the expertise and skills these jurists are generously willing to share with us. We are grateful for Dean Carrie Abrams' consistent support of our intramural moot court competitions, including the Hardt Cup, and this round would not be judged by a panel of this caliber without the efforts of Dean Abrams, Sarah Emily, and Lee Marquez. We value the Hardt Cup tradition of having professors and practitioners judge the quarterfinal and semifinal rounds. So we would like to thank Professor Mark Anderson, Cravath, Swain, and Moore Associate Margaret Anderson, Professor Sarah Sun-Beal, Dan Bowling, Sarah Boyce, Nick Broad, James Cox, Shane Ellison, Marilyn Forbes, Jenny Kim, Giovanni Martinez, and Veronica Root Martinez for setting aside time to participate as judges. This tournament would also not be possible without the hours every member of the Moot Court Board spent judging arguments, and we appreciate the effort of every board member that they put into learning the many problems, and especially thanks to those who volunteered to fill judging positions at the last minute. I'd also like to thank those who went above and beyond, Margaret Krusner, which is our intramural coordinator this year, as well as our Hardt Cup coordinators, Josh Britt, Gina Campanelli, Kylie Groft, and AJ Peterson. To introduce our finalists, we have Justin Fizer for the petitioner, Mike Campbell. Justin is a 1L from Randolph, New Jersey. He graduated from Columbia University and the Jewish Theological Seminary in 2019. Justin worked as a paralegal both at a big law firm and a credit firm before law school. At Duke, he is president of Outlaw and a 1L representative of the Jewish Law Student Association. And Megna Melcote for Respondent, Missouri State Representative Sherry Tolson-Raich. Megna is a 1L from Music, Pennsylvania. She graduated from the University of Richmond, where she studied philosophy, political science, and music. At Duke, she is involved in the Duke Law Music Association and the South Asian Law Student Association. And finally, I want to introduce our judges. The Honorable Catherine Eagles, U.S. District Court for the Middle District of North Carolina. Judge Eagles was nominated to the United States District Court for the Middle District of North Carolina in May 2010. She graduated from Rhodes College and from George Washington University School of Law. Following graduation, Judge Eagles clerked for Judge J. Smith Henley on the 8th Circuit Court of Appeals. She then joined Smith, Helms, Mullis, and Moore in Greensboro, North Carolina, where she worked from 1984 to 1993 as an associate and partner. In 1993, she was appointed to a seat as a resident Superior Court judge based in Greensboro. She was elected to serve the remainder of the term in 1994 and re-elected in 1996 and 2004 to 8-year terms. In 2006, she became the senior resident Superior Court judge in Guilford County. Next, the Honorable Carla Wong McMillian, Georgia Supreme Court. Justice McMillian was appointed to the Supreme Court of Georgia in April 2020. She is the first Asian Pacific American to serve on the state's highest court in the southern United States. Judge McMillian graduated from Duke University and received her Juris Doctor from the University of Georgia School of Law. She clerked for Judge William C. O'Kelly in the United States District Court for the Northern District of Georgia before joining Sutherland, Aspel, and Brennan LLP. There, Justice McMillian became a partner and built a practice centered on complex business litigation. Justice McMillian was appointed as a state court judge for Fayette County in 2010 and re-elected in 2012. She was appointed to the Court of Appeals in 2013 and won re-election the following year, becoming the first Asian American to be elected to a statewide office in Georgia. And lastly, the Honorable Julius Richardson, U.S. Court of Appeals for the Fourth Circuit. Judge Richardson was appointed to the United States Court of Appeals for the Fourth Circuit in August of 2018. A graduate of Vanderbilt University and the University of Chicago Law School, He clerked for Judge Richard Posner of the U.S. Court of Appeals for the Seventh Circuit, and then for Chief Justice William Rehnquist of the United States Supreme Court. Justice Richardson then worked for 3 years at Kellogg, Hanson, Todd, Figel, and Frederick in Washington, D.C., doing complex litigation. In 2009, he became an assistant United States attorney for the District of South Carolina, where he prosecuted criminal cases for 10 years and was deputy criminal chief before becoming a judge. Again, I'd like to thank you all for joining us for the 2003 Hardt Cup competition. Please silence your phones and please refrain from crumpling with a few of your treats while our petitioner and respondent are giving their oral arguments.
Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God bless the United States, and God bless this court. We will now hear arguments in case number 23-1001, Campbell versus Reich.
Good morning. We're all ready. We'll hear from the petitioner. You may proceed.
Madam Chief Justice, may it please the court. My name is Justin Fizer, counsel for the petitioner, Mike Campbell. With the court's permission, I'd like to reserve 2 minutes of my time for rebuttal.
Granted.
This is a case about right and a wrong. Specifically, how Sherry Reich was wrong to block Mike Campbell on Twitter because it violated his constitutional right. Here, the court should reverse the appellate's decision for 2 reasons. First, Sherry Reich was wrong to block Mike Campbell because she was operating under color of law pursuant to Section 1983. Second, Sherry Reich was wrong to block Mike Campbell because she was engaging in illicit viewpoint discrimination within a designated public forum. First, Reich was operating under color of law pursuant to Section 1983. As this court held in the case of Brentwood Academy, to act under color of law, actions need only be fairly attributable to the state, which is, quote, a matter of normative judgment. This is a holistic test.
Help me understand that, counsel. I mean, that's stating the conclusion, right? Well, I understand our court has previously said this, but what sense does it make to ask whether it's fairly attributable? That is the conclusion, right? It's not a test, is it?
Your Honor, as this test has been applied in other cases, we can see how Reich would also be deemed to be operating under color of law. For example, as in the case of Knight v. Trump.
No, but I understand that. But what I'm asking is, why is that the test, right? You're saying what we ought to ask is it fairly attributable? That's the conclusion, right? It strikes me that the test is whether they're acting on behalf of the government, right? And that's a question about their, power or their, official duties, right? But that's the test. Is this within their official duties? Not whether it's fairly attributable, right?
Your Honor, for example, to answer the question, in the case of Haaland, for example, the court held that Congress acted within the scope of employment when criticizing opponents on Twitter because the act of communicating one's views, for example, to the public falls within the wide range of legitimate errands performed for constituents.
All right, but I understand if you're adopting that position, I take what you're saying is you agree that it has to be part of their duties in order for it to be a state actor's question. It has to be part of their duties. That's what it means to be fairly attributable, right?
Yes, Your Honor. And as we'll see, by blocking Mike Campbell, Sherry Reich was letting her position be known on something which constitutes under Haaland as operating within the scope of employment and operating under color of law. Some
Is that-
examples.
So anything that she does in her personal, private life is under color of law then, just because, if she expresses an opinion, just because she's a public official? Is that what you're saying?
No, Your Honor. As the court holds in Dossett, for example, an official can still act under color of law despite other actions simultaneously furthering personal goals. There's no direct line here, but
What exactly is the official duty you're saying that she is performing in having a Twitter account? Are you saying it's just expressing her opinion about certain issues? Is that part of her official duties?
Your Honor, as the district court found, Sherry Reich used this account to discuss political topics and indicate her positions relative to other officials. This is part and parcel of the many things that Sherry Reich used this account for, which, with the court's opinion in Howland, finds that sharing one's views falls within this range of legitimate errands.
So help me understand why we should think sharing her views is part of her official duties. Right? I would think naturally what we would do is we'd go to the Missouri Constitution and we'd look and see what the Constitution says her duties are. And if you do that, you can accept hypothetically, it doesn't include sharing one's views, right? Her duties revolve around voting on things, right? Engaging in lawmaking and budgeting and confirming judicial nominees. Those are her duties, not sharing her views.
Your Honor, as the court also says in Davison, an action taken by a government official is also fairly attributable to the state when the sole intention in taking the action was to suppress speech critical of her conduct of official duties or fitness for public office.
But that begs the question of whether what she was doing when she blocked the account, that's asking what the effect of blocking the account is. We're asking the question, not that one, which is blocking the account an official duty? Is that part of her official duties? Like, was it a vote, right? Was it a hearing, right? Was it part of the speech and debate? No, there's none of those things, right? It doesn't strike me that it's any part of her official duties.
Your Honor, the tweet in question was clear to quote that they found that Reich's behavior was, quote, unacceptable from a member of Boone County delegation, which was critiquing her fitness for office. The tweet in question, therefore, was blocked, which shows her sole intention that she did not want to have such content anywhere near her wall, and she was making her intention known to her constituents.
Isn't that really part of her campaign conduct? Because, I mean, she started this account in order to gain the office. She did, and, you know, she has to keep running. So, I mean, isn't that just part of her attempts to, you know, make sure that she can win her next election? And that's private conduct, isn't it?
No, Your Honor, because, for example, in other court cases that we've seen of officials acting under color of state law, for example, in Knight v. Trump, the court found that Trump was operating under state law by announcing, describing, and defending policies and promoting his legislative agenda. And here, Reich did those things.
But didn't, in that case, Trump's attorneys basically conceded that he was making official statements through his Twitter account? I mean, there's no concession in this case, correct, that she was making official statements or anything like that?
Your Honor, there's not an explicit mention. However, similar to that case, what we can see from Sherry Reich's account is, quote, trappings of an official account, which was noted for the Trump account as well. For example, using our normative judgment, we can see that having a Twitter handle, for example, MO44, a clear designation that someone is working for the Missouri 44th District Legislature, having hashtag MO44 and hashtag MOLeg, standing for Missouri Legislature.
So if this was a speech, she's just making a speech, are you obligated to shut up while somebody calls you names or disagrees with you? Why do you have to give your opponent, somebody who disagrees with you, a public forum in this situation? I mean, why is she obligated? That's what we're saying, that she is obligated to give somebody who disagrees with her a public forum when they can disagree with her any number of other ways. And so I'm not really getting that.
Yes, Your Honor. It's exactly because Reich opened up a designated public forum that she is obligated to let people speak. As this court holds in Cornelius, viewpoint discrimination is when a government official takes actions impermissibly motivated by a desire to suppress that particular point of view, as we've seen with this tweet. And as this court holds in Mansky, that is not allowed viewpoint discrimination is not allowed in public forums. Now, the test that this court holds to determine a public forum is the courts must look to the policy and
Before you
practice.
turn to public forum, can you go back to this idea? But the question we have is whether this was a state action. And do you agree that the action here was blocking the account in this instance? The state action is not the tweets that she's otherwise making. The only state action here, as I understand your complaint, is that she blocked someone, right? And so I guess I'm a little confused why. I mean, I understand we want to talk about these other tweets, but we're not asking whether those are state action. We're asking whether the blocking is state action, right?
Yes, Your Honor. And again, viewing her account in totality, we see that this account.
No, but I don't want to look at the account in totality, right? Because we don't look at the totality. What we ask is this state action? The
Yes.
action here is blocking. And so I guess I'm a little curious why we're talking about her tweets and trappings at all.
Yes, Your Honor, because again, demonstrating one's views and communicating to one's constituents falls within the wide range of the legitimate errands that a politician can do. Therefore, by blocking certain
Can
people,
do, or in your views, those are the official duties. They're required to do those, right? Don't
Yes,
you
Your
have to
Honor.
say they're required to do those?
Your
So
Honor,
they can do them. I mean, they can go to the grocery store, right? But they have to be required to do it for it to be an official duty, right?
yes, Your Honor, as the court found, that is part and parcel with the duties. However, it's not so much a question of can a politician do it, it's that Sherry Reich did do those things here. She did block Mike Campbell, which let 122 people, in addition to Mike Campbell, know that the kind of speech that they were merely retweeting on their own page was not something that she agreed with, which in essence was communicating her views to the constituents.
Oh, but she has a right to communicate her views, and there's nothing stopping Campbell from tweeting whatever he wants to about her. I mean, blocking does not stop him from tweeting all sorts of criticism about her, correct?
Your Honor, as this court found in the case of Sorrell, workarounds to burden of speech, for example, are still burdens that run afoul of the First Amendment. Workarounds, for example, of my client either creating a new account or trying to figure out other ways to reach her still do not cure the constitutional violation.
There's no constitutional right for you to reach an elected official. I mean, we've been pretty clear about that, right? I mean,
We're not talking about the petition clause today.
No, Your Honor. The breach that happened here was that my client was silenced. That's exactly what's happening here. In a public forum, a politician here saw something.
Was your client kicked off of Twitter?
No, Your Honor, he was not.
Was your client like prohibited from being on Twitter? I understand why you say he was silenced, right? That's maybe the word, maybe the rub that we're having. Why do you say the word silence? I mean, that, to be totally fair, seems exactly wrong to me.
Your Honor, because Reich did not limit the interactivity of her Twitter account, it became a designated public forum as a politician. Had she had kept it limited to a private account, akin to, for example, she has a private Facebook account.
Can I ask that? You said she did not limit it, right? But we've said, and the Supreme Court's repeatedly said, right, it requires an intentional opening of a forum, right? Not a negative, right? You've said you got to take an affirmative action to keep it from being one. We've said it requires intentional action. Right? Not the opposite, right? Hadn't you flipped that on its head?
Your Honor, the intentional action here was that Sherry Reich decided to open up a profile on Twitter. She assented to the terms.
So it's any public official. So your position is that any public official, if they open a Twitter, even if it's to just tweet about cats, right, that is now a public forum because they haven't taken official action otherwise.
Your Honor, compared to her Facebook, Sherry Reich was.
Wait, do you agree with that? My cat Twitter, right? Right? Judge J at cats dot whatever.
Yes, Your Honor. The law is clear here. Now, the policy.
Yes, you agree that that's a public forum, that my cat Twitter is a public forum.
You have 1 minute.
Your Honor, the court in Cornelius here makes it clear.
No, but I want to know the
hallmark-
answer to the question first. Before you go to a court, tell me, is my cat Twitter a public forum, a limited designated forum?
Your Honor, it depends on if you are doing something to limit the interactivity of that particular Twitter account. Twitter, you are able to limit that. However, Sherry Reich did not engage in such practice. She decided that this was an open forum for any of her constituents to like, comment, repost, retweet, reach at her. And until she found something that she didn't like, she let her intentions be known and decided to block 123 different people.
You have about 15 seconds to wrap up.
Your Honors, for the following reasons, Sherry Reich was wrong. She was operating under color of law by letting her position be known to the constituents, violating Section 1923, and she did not limit the interactivity of her Twitter, which designated it as a public forum, and she is not allowed to engage in such discrimination. For the foregoing reasons, please reverse.
Thank you. For the respondent. May proceed.
Madam Chief Justice, and may it please the court. My name is Meghna Melkote, and I represent the respondent, Sherry Reich. This case is about a clear line between promoting free speech and protecting unwilling listeners. Because, Your Honors, the right to speak is not the right to be heard. Sherry Reich blocking Mike Campbell is not a violation of his First Amendment rights, and he doesn't have a claim under Section 1983. That's why we'll ask you to affirm the decision of the Eighth Circuit for two reasons. First, Reich wasn't acting under the color of law. And second, her Twitter account did not constitute a public forum. Now, first, Reich wasn't acting under the color of law. Now, to determine if an action is fairly attributable to the state, we have to look at a few factors. And one of those is in Martinez versus Colin, asking whether the actions occurred in the course of performing an actual or apparent government duty. Now, Your Honor, of course, there is no duty for an official to have a Twitter account. And we have to look at whether or not that Twitter account was used as a tool of governance. Here, she started her account as a campaign account, and Your Honors, it never changed from that.
So is it your position that a legislator, whether a county commissioner, city councilman, or a legislator, can never have a public forum because they can't act alone other than to vote?
No, Your Honor, we believe that a public official can act under the color of law if they're using it as a tool of governance, like in Davison v. Randall. The difference between that case is Randall was using that account to share critical information for the first time with his constituents. Randall was using it to coordinate removal about serious safety events like snow removal.
I took my colleague's question to be a little different, right? Because that's an example of an executive, right? And we think about executives, particularly in state government, as having an array of residual powers, right? They do lots of things. Legislators, by definition, are much more limited, right? They act as a body, which means as a broad sense, they act only by voting. And so I sort of thought your answer to my colleague's question was going to be like, oh, I totally agree. No legislative account could be a public forum that is state action.
Your Honor, a legislative account could be state action because it could be state action in the case where they're, for example, sharing something new for the first time, so saying some kind of legislation that they're going to propose, or sharing any.
Why is that?
Why? I'm sorry.
Well, I think we're asking the same
Right.
thing. Why is that state action?
I'm not trying to make your argument for you, but I don't understand why you think that is state action at all. In fact, it's not, you said, is it the part of the government duty, right? And the government duties of a legislature are to vote and to speak and debate, right, in the legislature, right? To the extent they do things outside of the legislature, maybe it's campaign focus, maybe it's just personal pride, maybe, it's vanity. Who knows? Doesn't make any difference to me. It's not an official duty.
Your Honor, we agree. And Your Honor, it's not our contention to try to draw a bright line as to what can and can't be a state account automatically. We're just here to say that the duties of Reich in this case did not constitute a state account. And to the extent that the duties of this account can be imputed onto the duties of other legislatures, Your Honor, that would also make sense because of the very nature of state action by those officials.
Would you agree that if she only reported her votes, right? She said, I voted yes on Proposition 34. I voted no on 35. Do you think that would be state action, like just reporting her votes?
No, Your Honor, it would not be state action.
Why not?
Because one of the factors to determine whether something's state action is under Rosignol if they're doing things that private citizens couldn't. Rosignol versus U.S., if they're doing things private citizens couldn't do. And, Your Honor, reporting on what she's done is something a journalist could do. Any private citizen could report on what's been happening. And so, Your Honor, her simply sharing what she's doing with the public doesn't amount to state action.
Let me ask about this. I mean, in an analogous context, and what if she had held a town hall, she invited people to come listen to her, give her views. can she block people from coming to her town hall?
Your Honor, that would get into the second part of the analysis, whether it's a public forum, and in that case, she couldn't.
Is that part of her official duty? It's not voting, but she is acting in her capacity as a legislator to inform her constituents about what's going on. She's inviting everyone to come and speak to her about it.
Your Honor, it would depend on the nature of what she's saying in that town hall. And
And she says exactly the same thing she had said on Twitter.
Well, Your Honor, in that case, then that wouldn't be a town hall event. That would be a campaign event, because every single action she took here was.
Is there ever a difference?
Your Honor,
And by definition, when politicians are holding town halls, they're really holding campaign events.
Your Honor, we believe there are situations in which there could both be a town hall and campaign event, but not in the contours of this case. Certainly, one could be making themselves look good in a town hall event, but in this case, the tweet in question was specifically referring to her opponent. It was only in the context of a campaign, and all of her tweets had to do with how good of a job she was doing as an official and why she should be elected. So in that case, Your Honor, it wouldn't be a town hall. It would just be a campaign event, similar to what she's doing now.
So if she tweeted only things like, I have scheduled a legislative committee hearing for date, time, and that was the only public notice of a hearing, just imagine that. That would be state action, right, if she did that?
Your Honor, under the relative test, that could be state action, but it depends on a variety of factors without drawing bright lines. And it's clear that the factors in this case were so clearly not met because there weren't tweets like that.
If you were going to draw a bright line, what would it be? Bright lines are easier for trial judges to administer.
Of course, Your Honor, a bright line would be looking
For people to
Why would we do
understand.
that?
Exactly. Why would you? And for people to understand, I mean, isn't it a good idea to have clear rules that people can actually follow so that you don't have violations and lawsuits all the time? Wouldn't a bright line rule be better?
Your Honor, we can try to draw a line by looking at two cases, Davison v. Randall and Morgan versus Bevan. Now, in Davison v. Randall, the court held that it was a violation because of the nature of the account, and they held that it was because they were expressly asking citizens to use it as a channel of communication. It was expressly designated as an official page of a state actor. So that's one side of that line, official designation by others, which did not occur in this case. On the other side.
So in that case, Morgan, that was a governor, an executive official who did that, right?
Yes, Your Honor.
Okay, go ahead.
Your Honor, in that case, there were so many of the trappings of state office that we need to consider as a factor that count is clearly part of state action. But in this case, there weren't any of those trappings. It wasn't designated as an official account at all, like it was in Knight versus Trump, and like it was in that case. And furthermore, Your Honor, those trappings just didn't exist based on the fact that it was never communicated to constituents of that official role of the Twitter account.
I'm sorry, say again?
It was not communicated to constituents that it was meant to be an official state account. It was only meant to be a campaign account. Given her tweet, she was saying she scored an A and accomplished much. It's very different, and it never changed its purpose.
But she didn't explicitly say that either. She never designated, this is my campaign account. That was not explicit either once she was elected, right?
Yes, Your Honor, but she doesn't need to explicitly designate it because unlike the case of Davison v. Randall, that Twitter account was made right after he got elected. So it started off as an election account. This started as a campaign account, and there's no need to designate that it's a switch or that it stayed the same.
Of course, you can designate it and it not be an accurate designation.
Of course, Your Honor, but in this case,
Politicians, we're not politicians. Politicians have been known to misstate things from time to time, right? So this official
Judges would
designation-
never do that.
Yeah, just designation idea, is that a good black and white line to draw, that you've designated it or you haven't? Because you can inaccurately designate.
absolutely, Your Honor. We're not saying that someone does not have to designate it, but in this case, she did not even designate it as a campaign account. She didn't say anything. So in this case, we have to look at what she was actually doing, which avoids the problems of politicians lying throughout their designation, because all of her tweets were campaign related.
Where would you have us look to identify her official duties, right? We sort of keep coming back to this idea of official duties. Where should we be looking to identify what her official duties are?
Your Honor, if they're occurring in the course of performing their government duties, so for example, things that a government...
Where? But help me understand where I find that. What am I looking to? I mean, am I just sort of like trying to give my best guess of what a legislator does?
Your Honor, it's a holistic review. We're not asking you to give a guess as to what a legislator does, but we can see when someone's acting as a state official and someone's not. So one example is if they're saying they're acting like a state official, or other people are taking these to be accounts on official actions by a state office. So that's one way to designate it. Another is the Resignol test, looking if she executed an action in a manner private citizens never could have. So those are two factors to consider that clearly show that Reich was not acting under the color of the law. Now, Your Honor, for the second part of the analysis, even if she was acting under the color of the law, the nature of her account is private, and therefore she did not designate a public forum. Now, my opponent talked about how Reich did not limit the account. Reich did not put any blockers on or put any filters on. But, Your Honor, it does not require that Reich take affirmative action to close herself off.
Right, but so help me understand that the nature of Twitter seems like an intentional act, right? Like if you put yourself onto Twitter, right, in my cat example, right, I've chosen to go put pictures of cats on Twitter, right? And I know by doing that, or at least maybe even I hope, but I know that some people are going to retweet it, right? Some people are going to reply to it. Some people are just going to make fun of it, right? I'm fine with all of those. But it's necessarily interactive, right? Why isn't that enough intentionality?
Your Honor, because the court has not held that by simply logging onto a private platform and entering it, there's a designation of a space. The court has held an
Yeah, but in the nature of Twitter that it is a space, so when I join, that's the intentionality, right? Like if I join a different website, perhaps it's different, but Twitter is by necessity interactive, right? That's the nature of Twitter, right? So why isn't the intentionality to make this a designated public forum that action?
Your Honor, if the intentionality is inherent in the public forum, which is simply a private account, that would destroy the test in Cornelius, that it has to be private property dedicated to public use. While there may be interactive features of Twitter, taking that approach that a private platform is inherently interactive, so there's always a public forum, destroys the difference between public and...
It's different. It's you've got a public official self-identifying themselves as a public official, talking about what she does for her constituents. It is a way for her to exercise her public duty of letting her constituents know what's going on, right?
And to my colleague's point, she's implicitly asking for responses because it's open to responses. She's inviting responses from everybody except Mr. Campbell, who she doesn't like. So why is that not taken together?
Your Honor, an implicit invitation is not enough. There has to be an express invitation, and the court has seen that in Morgan versus Bevin, in which they held that because there was no explicit invitation and because...
Is Twitter explicitly explicit?
No, Your Honor.
I mean, an explicit invitation, just unless you block everybody, why is it not an invitation to respond?
Your Honor, Twitter is not inherently an invitation to respond because it would make, by that argument would make Twitter by its design inherently a public forum. And making a private account inherently a public forum destroys the line between public and private eras. And it also destroys the test that it has to be private property designated and dedicated to a certain use. That's why the court has those differences between a traditional public forum and a designated.
I can understand that if she had a cat Twitter, maybe that's not a part of her public duties. But, I mean, she is talking about what she does as a legislator and what she does for her constituents. And she allows people to respond, reply, like, retweet. Why is that not a designated public forum, at least for, you know, the things that she's putting out there?
Your Honor, it's not a designated public forum because there was never an invitation for people to contribute. Allowing people to contribute and not stopping them is not the test as to what a public forum is. And furthermore, Your Honor, unlike in Davison v. Randall, she's not trying to create an electronic marketplace of ideas.
Why are you on Twitter then? I mean, instead of, I don't know, you could do a Snapchat, I guess, and just like let people know what's going on and not really invite responses.
Yeah, just have a web page.
Yeah.
Your Honor, it's our contention that Twitter is a good way to reach constituents, but it does not inherently mean it's a way to interact with them. And it's our contention that she used Twitter like a newsletter. She used Twitter as a way of communicating.
Maybe you should find a service that's more like a newsletter instead of an interactive service. I mean, isn't that part of the problem with your argument? I mean, this service inherently promotes interaction. That's the whole point of tweeting, I think, is to get interaction.
Yeah,
Yes,
1
sir.
minute.
Yes, Your Honor. Well, tweeting definitely supports interaction. It doesn't mean that she's expressly designating it for interaction. It's simply similar to a newsletter, Your Honor. People can respond to newsletters. They can talk to each other. It's the same with a Facebook page. There's interaction that can be inherent in any sort of social media. But the key when private property takes that leap and becomes a public forum is that there has to be an invitation and express designation. And Your Honor, furthermore,
She's inviting it, isn't she? By putting it out there on Twitter in a format that lets people respond?
no, Your Honor, because it doesn't require her to take affirmative action to close it off. It requires her to take affirmative action to designate it as such. Okay. Now, Your Honor, because she was not acting under color of law and because her account did not constitute a public forum, we ask you to affirm the decision of the Eighth Circuit. Thank you all very much.
All right, thank you. I believe you have 2 minutes for rebuttal. Go ahead, Mr. Fisser. I hope I said your name right.
Pfizer, Your Honor.
Pfizer, pardon me.
Thank you, Your Honor.
Go ahead.
Yes, Your Honor. The respondent's case fundamentally fails because of a misunderstanding of how to understand a public forum. Whereas my colleague here says that it requires an affirmative action, nowhere does the Cornelius or Rosenberger test ask as such. Instead, the court is clear that we look at the compatibility of expressive activity to discern government intent, which here, operating on Twitter, is in itself inviting. Any of Reich's constituents can comment, like, retweet. It is an open invitation, and it is not a newsletter. Again, to quote Your Honor Richardson.
So let me go back, because I read Cornelius to say the government has intentionally opened up for that purpose, close quote. You say it's not about intentionality, but I read Cornelius, the language just says intentionally opened up.
Yes, Your Honor. By going on Twitter itself, that shows the intent because Twitter itself is a private company dedicated for public interaction. Whereas she could have taken steps to limit.
We all know that you can be a Twitter stalker, right? So you can be somebody on Twitter who has an account and follows other people and is a consumer. But that doesn't mean you've intentionally opened it up. So you can obviously join Twitter without intentionally opening up your account for that purpose.
Your Honor, however, that's what Sherry Reich did, because to quote this court in Rosenberger,
isn't it critical that it's necessary? My point is it's not necessary, and if it's not necessary, that's not the intentionality that's required, no?
Your Honor, an account with interactive features open to the public, making interaction a prominent feature, as done in Twitter here, means that the account is not private. There is no requirement that Sherry Reich has to say, come one, come all, everyone can comment. By opening up on Twitter and the way that Twitter operates, Sherry Reich is telling her constituents, this is a designated public forum because anyone can like and comment. Now, to answer the question about state action, again, looking at Davison by saying that suppressing views on her critical fitness for office, may I briefly conclude, shows that she was doing a state action by blocking my client, and I urge you to reverse. Thank you.
Thank you. The court will take the matter under advisement. Well, first of all, what a pleasure to be here today and to see two really good advocates. And, when I realized, again, y'all were first-year students, I was so impressed. Y'all both did such a good job. I'll just get right to the point and say that we are ruling for the respondent, Ms. Melcote. Congratulations. That said, y'all both did a good job. You were very well prepared. You knew your cases. You had your case law at your fingertips, both of you. And it's not surprising you were here in the finals. So, Ms. Melcote, we appreciated your ability to engage with the bench and to respond to the questions. You might want to slow down a little bit. You've probably been told that before. and you'll probably be told again. But that you were very, very good about that. And if the court's making your argument for you, recognize the softballs and go with them. But really, you were very prepared. You were very engaged, very responsive to the questions. And Mr. Pfizer, you had kind of a hot bench that was not really buying what you were saying, but you were not rattled. You, for the most part, you did not allow the judges to bully you into conceding more than you should, which is really easy to do, and you didn't do it. So good. And you clearly had the cases right at your fingertips. So I'll invite my colleagues for other comments.
Yes, well, I guess I would say congratulations to both sides again. I mean, I'm a Duke undergrad, a Duke alum, so it's always great to be back on campus and seeing the quality of the students here in the law school. I'm really impressed. For both sides, I think you did a great job setting up your arguments. And I know we were a hot bench, and you probably didn't expect to get a cat Twitter question.
I'm sure that was part of the moot, right?
Yes. And so, I mean, congratulations to you to, keeping on point, and trying to work through that. Also thought your rebuttal, you did a good job with your rebuttal, because we kind of didn't let you go to your second argument that much, and you took that time and did that. Ms. Melcote, I think you did a great job also answering some tough questions from the bench as well. So congratulations to both of you.
So I thought you both were great. We'd love to have you, right? The real answer is one of the things that's surprising when you come and see advocates like you. It makes you appreciate, how quickly y'all could step in and very easily, perform at the top of the field in our court, at least. So I'll just focus on you since you won. You did great too, but you won. So I thought you did a great job of setting it up and giving us a framework to think about, right? When you're arguing, you get these first, maybe 30 seconds, maybe 15 seconds. I thought you made great use of that, sort of, framing the case for us as a balance that we are trying to draw. And I thought it was a helpful framing for you. I thought you were conversational. Right? I mean, really, the whole idea of this ought to be having a conversation with us, right? I really wish at some level that we would have argument where the lawyers would sit down, right? Not because, of anything other than I think it would make us more conversational. And really, that's what we're looking for. It's not a speech. It's not a presentation or a performance, right? This isn't Hamlet, right? This is a conversation. And so I thought you did a good job of being conversational. And I also thought you did a very good job of engaging with our questions. I mean, part of the whole point here is to ask a little bit of off-ball. I didn't plan to ask the cat question, right? But is to ask a little bit, hypotheticals and oddities and try to push you in places that you weren't sure where to go, which way I was going. I thought you did a good job of engaging in that conversation. So congratulations. Well done.
Right.
Thank you, everybody, so much. Thank everyone who
Can we shake their hands?
Oh, yeah. Oh, yes.